Erin Zavislak. She is Holistiplan's Senior Product Counsel for Estate Planning, which, as you know, has been heavily teased. We are super pumped about it. The team has been incredibly hard at work over the last couple of months since we announced it. And today, Erin is going to talk through the top 10 estate plan gotchas. So, Erin, come on down.
I feel like I'm on a game show. Hello, everybody. I'm
You
so
win.
excited. I did win. I'm so excited to be here. I hope you've been really enjoying the presentation so far. I'm going to try and keep it light today. We'll do client stories, which I feel really allows us to get a little bit deeper into the complexities that advisors face when assisting their clients. So, let me go ahead and share my screen. And we are going to try and save some time for questions as well today. So, okay. Laura, can you let me know that my screen is sharing?
So, I cannot see your screen right now.
Oh, technical difficulties. One moment, folks.
What had to happen at some point? It's a live show. Here we go.
Oh, yeah, it had to be me. Okay, how about now?
Looking good. All right, go for it, Aaron.
All right, awesome, everybody. So, what is a gotcha? We reflected on this a little bit and really thought about what do advisors face when assisting their clients, not only in the planning phase, but also the execution phase. So, I think advisors are in a really unique position to assist clients in estate planning from both of those lenses. And we all know the common pitfalls or gotchas in estate planning. Beneficiary designations that are not completed, the failure to name an agent under a power of attorney, or a trust that was signed but never funded, right? But what is really important about an advisor community like Holistiplan has created and what we are creating around our estate planning modules is the stories where the practical implications meet the theoretical. And we all carry these stories from our own personal experience. New advisors that are starting out, they haven't had the opportunity to learn from clients' mistakes before. But what if we had a software and a community that allowed that collaboration so we didn't have to learn these gotchas on our own and we could prevent our clients from experiencing these in the future? So what you're going to see in these client stories is there's no major litigation, right? There's no major malpractice, but these types of fact patterns present themselves over and over again. And so I think our goal should really be to help our clients avoid these situations. So let's get into the first. Dueling executors. Okay. So, how many times have we sat with a client, gone over their estate plan? They told us that their children were named as executors or trustees or maybe their best friend. But have we ever inquired into the thought process that went around choosing those individuals to serve on their own or together? Or maybe the preference for an individual versus a professional, like an entity, like a bank or a trust company. So, this is the story of two sisters that got along perfectly well until they didn't. So, in this case, their father, the testator, under his will, had decided that he would name both of the sisters jointly to be executor. So, that's a fiduciary role. Relationships became strained regarding end of life care decisions for their father. So, this is extraneous circumstances that come in that are outside the will. Each executor is entitled to hire their own counsel. They are joint fiduciaries. And in this case, the sisters not only hired their own attorneys, very expensive attorneys, but decided that every decision that they needed to make jointly would be made with the help of both attorneys. And so anything from accounting to court filings to tax returns, in a way, became a matter of litigation. The estate was $10 million. And when I got involved with this particular client scenario, the attorney's fees, not even the executor's fees, but the attorney's fees were almost 5% of the $10 million, which is wild. Neither executor pays for those fees themselves. They are an expense of the administration of the estate. So, what is the gotcha, or more importantly, the lesson learned here? Clients don't necessarily put a lot of thought into the agents that they name. Sometimes it's more reflexive. I want everybody to feel equal. I don't want to cause any hard feelings. These are my children, for example, who better to do this, right? We also find that estate planning attorneys don't necessarily go that deep into the selection of agents and fiduciaries. And maybe it is a sensitive subject. Maybe we don't feel comfortable questioning a client's decisions. But what I will tell you is rooting in the process that the client undertook in making those selections can help take the emotion out of, the assistance in facilitating that particular conversation. Because day to day, we interview folks. We interview folks when they're applying for a job. We interview folks when we're looking to have work done on our house. So the question really becomes, what is the ability and willingness and skill set of these individuals to carry out these duties? Do we even really know what they're going to be asked to do? And then importantly, when named together, what is their propensity to be collaborative in that? Bank of America did a study in 2024 where they sent out surveys to wealthy individuals that were in their client book. And what they discovered is not going to be new to us. A major concern in the estate planning process is keeping family whole, right? Not causing any harm or opportunity for conflict. That dynamic is a big concern for clients. And additionally, from those individuals that were named as executor or trustee, they described their feelings around that to include a range of I feel burdened to I feel anxious. Okay. So there are feelings not only from the client's perspective, the beneficiary's perspective, but also the individuals that are being asked to take on the responsibility. And advisors sit in a unique position to be able to facilitate that goal discovery, understanding that process, and raise some of these opportunity areas, oftentimes through storytelling. Yep. The next gotcha. Who has the power? So we just talked about designating fiduciaries under an estate plan and what's the process that goes into that. In this particular situation, there were multiple dynasty trusts that were created for a very, very large family. At the time that we got involved with them, there were 56 individual beneficiaries. This particular document required a corporate trustee to be in charge of the trust, and these beneficiaries disagreed with that corporate trustee's investment philosophy as well as their investment selection. And it had been decades. So, doing a little Monday morning quarterbacking here on the situation, the question becomes the family knows that they need a corporate trustee. How do they go about facilitating that? Well, in this case, this corporate trustee did not want to voluntarily resign. So the family was looking at ways to either entice the corporate trustee to give up these very large trusts or to remove this individual. This particular document did not specify either an individual, such as a trustee appointer or maybe a trust protector that would have the ability to make these decisions, or a group of individuals. Okay. So this family was looking at all 56 agreeing. Not all of them were even in the country. So what ended up happening is that after significant time trying to resolve this out of court, the family ended up in court trying to limit how many beneficiaries were going to have to agree to this. This is a very time intensive, expensive process. And sometimes what folks will do is they'll look to what's called virtual representation statutes. They vary by state law. Advisors are probably most familiar with the idea from when a parent will represent their minor child in signing paperwork or agreeing to something, right? But there's all various abilities to represent another individual. Um, this family finally got the job done, very protracted, had to rely on all the state default laws with the assistance of attorneys. So the lesson learned is really to think about what could come and what flexibility the client might want to be able to make changes after the fact. And if flexibility is wanted, which individuals does the client trust to be able to make those well-reasoned decisions to make a change here? So facilitating that particular conversation so that it can be communicated to the estate planner. Frozen and frustrated. There are some advisors on this call that have experienced this, honestly, way too many of us. I'm still amazed by how close business partners can be, to the point where a business partner becomes somebody's name trustee, executor, in charge of, one another's estate plans. And in this case, a business partner named his business partner to be his trustee for trust under his estate plan. And what happened, which we all know with individuals, that individual had trust assets custodied at several different financial institutions, used checking accounts to be able to make distributions to beneficiaries. And in today's day and age, all of those records are electronically kept. Login credentials specific to the individual trustee, because the trustee is recognized as the owner of the trust account by the financial institutions, and biometric security. So when this individual passed away, all of these records were not accessible to the beneficiaries. What ended up happening is attorneys got involved, the financial institutions, legal departments got involved and had to interact with the widow's attorney, because she was named executor, in order to get access to those records and then eventually to unfreeze those assets, re-register them to the successor trustee. That was a period of months where folks did not have access to distributions under the trust, and they relied on credit cards. So the lesson learned here is that digital record keeping by trustees is common. So when we're naming individual trustees, we want to keep that in mind, raise that to your client. And then also security protocols. It can be biometric now, right? So these things are designed to protect the account from fraud, but they can have negative consequences. Even where a trustee or an executor provides periodic accountings to beneficiaries, they're not necessarily going to have access to all information to be able to unfreeze the assets themselves without intervention. Okay, simple isn't always easy. We all know about the use of LLCs and LPs specifically for tax planning. But when we uncover assets, especially things that are unique, that are not necessarily marketable, they're not held in brokerage accounts, I think what we need to ask the client to help them uncover is, although there's not a tax situation here, is there an administrative nightmare? Business partners, again, more common than one would think. Trademarks and copyrights. Two business partners owned 50% each individually. They both used living trusts, right? They're revocable, very common estate planning strategy here. One business partner passed away, the other one very prematurely, the other one survived for a period of years. Under the trust terms, what would happen is the individual beneficiaries of the deceased business partner, there were 16 of them, were going to get the trust outright. Very fractionalized interest in trademark and copyright. On the surviving business partner side, he was 80 years old. His trust was going to operate in much the same way. So now you have 20, 30 individuals who own a fractionalized interest in a very unique asset. And these folks without a corporate structure have to be able to interact. They have to be able to make decisions in concert. Things like who to hire as far as the agent to market this intellectual property, how to enforce the contracts against someone who uses the intellectual property without authorization. The administration of it can become very burdensome, especially for individuals that were not in that line of business, right? So sometimes what we think is simple, right? Two business partners, we don't have a federal estate tax problem. We're going to use living trusts for a period of time and then wrap those trusts up can end up becoming very complex. So that is the lesson learned here. Just because we don't have an estate tax problem doesn't mean we don't have an opportunity to look at the other side of the coin. Not the tax cost, but the actual costs and burden of administering an asset that is fractionalized among many, many heirs. Changing with the times. Duty to monitor. Who has the duty to monitor an estate plan? Is it the estate planning attorney who the client might see once every 5 years? Is it the client themselves? Should the CFP bring this up, in let's say when circumstances change, tax circumstances, assets, and then also routinely in an annual meeting? Here's what happens when it doesn't happen. And the feelings around this by this individual, Jim, went from I'm going to sue my attorney to I'm going to leave my financial advisor. We were all over the board with this. Emotionally, there was no malpractice, there was no failure per se, but did it defray the relationships that Jim had? Absolutely. And you're going to see why. So when Jim was in the process of a divorce, as part of that divorce settlement, he set up irrevocable trusts for his children. They were not yet age 18. This is not entirely uncommon. It's also not entirely uncommon to use someone who you're using for your divorce to also facilitate the drafting of those trusts, right? So in the moment, you're going through a divorce, you're thinking, I want to provide for these minor children, and you don't have a ton of clarity about what the future might hold. So you sign the documents, you get the deal done, they go in the drawer, and things change. Not necessarily with you as an individual who created the trust, but when you put yourself in the client's shoes, things are changing with his children. They're going through life events, right? And so as you pull out your estate plan when you're going through life events, you might want to do The same thing when your children are maturing and growing up. This was a case where this individual's son grew up, got married after many tries, was blessed with a pregnancy. There was family conflict. This individual and his brother ended up in an argument, and the beneficiary, Riley, passed away premature with his wife still pregnant with their first child. We don't necessarily contemplate that, right? That's a horrible thing to have happen. This trust did provide flexibility. The attorney put it in there. Riley had a power of appointment, the ability to change the disposition of his trust within certain constraints, for future things that could be unknown, right? That's a very powerful tool, the ability to have that flexibility. Jim didn't know. He put the estate plan in the drawer, never monitored it, and Riley was 17 when the trust was drafted, right? So what ended up happening was there was a dispute between Riley's brother, the sibling, and Riley's widow as to whether the default terms would apply. And a lot of it hinged, as you could imagine, on whether the baby would indeed be born, because of the stress that was put on the family during this time, and particularly the widow. There were health complications. The baby did end up being born. The baby ended up being the beneficiary. Unfortunately, the terms of the trust were not exactly what Jim would have liked. There were mandatory distributions to the baby, and in hindsight, would have preferred the trust to have accumulated. But that was an opportunity at that point that was lost. So the lesson learned here is that the powers of appointment are, don't look at it just from a tax perspective. Raise it, be aware of it, show your clients that that exists in their estate planning documents, and then find out what is the best way to monitor that. Is the lawyer involved routinely? Is it something that's going to be revisited by the client in regular meetings with you, right? Not a set it and forget it. Circumstances change. What is income anyway? You all talk about income a lot today, I'm sure, from the tax perspective. Wills and trusts, as I'm sure you also know, they have a different concept of income. It's fiduciary accounting income. And we'll go through one particular illustration to see why it's important, because most people don't really know about it, and your clients are probably not too sure about exactly how this works either. So in this case, before all of the modernization with the Secure Act and all the changes to inherited IRAs, this trust was set up to accumulate. So it was not a conduit, did not automatically pass through funds to beneficiaries. Mandatory fiduciary accounting income. Any additional distributions over and above that income were not allowed by the trust for a substantial period of time. Now, the trust documents generally do not specify how a trustee should do their own fiduciary accounting income. Two sides of a ledger, income over here, principal over here. But your clients understand, oh yeah, it's net income. Whatever the trust makes, they're going to get, right? Not necessarily so. So default rules again can get us here under different state laws. This particular arrangement did not specify, principal and income accounting for the RMD treatment. So the trustee followed the state default rules. 10% of the RMD went to income, 90% to principal. That principal was not accessible by the beneficiaries. So one might say, in hindsight, a got you was not understanding exactly what net income meant and the impact of these accounting rules there. Maybe Maybe there was more of an opportunity to more gracefully handle the income tax consequences to the beneficiaries versus keeping it contained within the trust. Maybe income was never thought of to be so small as 10%, but a lot of our clients now, they have a huge amount of their wealth in retirement assets. This particular case can't just happen with IRAs. It can happen with all types of different assets. Um, Basically, if it's not stocks and bonds and mutual funds, there is some really quirky default accounting rules here, not just from receipts, but also from debits. For in New York, costs could be 1/3 income, 2/3 principal. But if we're in Pennsylvania, it can be 50-50, right? If you have somebody who's only entitled to income, that can make a huge difference. So I would say make sure that when they get their trust summaries, they see what the terms are, right? And then they learn more about it. Question the lawyers, understand the default rules, and whether there's an opportunity to change them. Most of the time there are. You just don't need to go with the boilerplate. Okay. HEMS. Everybody's aware of health, education, maintenance, and support. I feel like it's probably on every standardized test or certification that we've taken in the financial industry. But what's important to understand about distribution standards is they're available on a spectrum. So the HEMS distribution standard under trust documents in particular, that's what we're familiar with. It originates from the tax code. We can refer to it as an ascertainable standard. It's actually a limiter, right? But distribution standards can go all the way up to you can give trust funds for any reason or purpose in the trustee's full discretion. Not very limited, very broad. Um, it is not unusual in my experience to have clients ask after the fact, why could my beneficiary get money? What would be a good reason? Why would you approve that? I say you ask that question before you sign the document because everything is really about the intent of your client. And sometimes they don't realize that they have that kind of agency, right? So in this particular case, what is health? This beneficiary was going through cancer treatment and wanted to engage in massage therapy and acupuncture, which is not something terribly uncommon now, right? But what you'll find is that trustees are often resorting to their own policies, their own procedures, and what very little, not federal, state specific law there is on the matter. And in order to create state-specific law on the interpretation of distribution standards and what should be allowed and what shouldn't, you need a court case. Somebody has to be willing to go to court. These beneficiaries have to expend money out of pocket to get that interpretation, right? So we often don't hear about these things, these war stories. And as part of our community, we want to make sure that we share them, we educate, we lift them up. So what's our lesson learned? There's a purpose for HEMS, right? And it can be suitable, but it's not the only option. And to understand that there are trade-offs here and things can be looked at on a spectrum, and to empower your client to think about the types of things they would want the trustee to make distributions for, and to have the agency to raise that to their estate planner. Supplemental needs is trust enough. What I really mean here, and I'm watching the time, is having a trust and trusting the trustee enough. So this is a boots and suspenders approach. Like the others, this is a real client situation. A $2 million trust was established for the benefit of a gentleman who had autism. He lived in a housing arrangement that was funded by Medicaid, and both of his parents were deceased. He didn't have any siblings. In this particular case, there was an entity trustee, so a corporation, as well as an attorney. And when this case got to court, the judge took a look and said, well, relatively no distributions for the benefit of the beneficiary, um, but plenty of distributions for trustee fees and expenses. So in this case, litigation actually had to occur to be able to get that court determination. And supplemental needs trusts, they are discretionary trusts, right? So we talked about mandatory distributions. These are discretionary trusts. Trustees often rely on the beneficiary to communicate that they need money. And sometimes that's going to include provide evidence, copies of tax returns, estimates for work you're getting done, bills that you need paid, cash flow analysis, budgets. That's a lot, for most people, let alone somebody who may need the assistance of another person. So this is a boots and suspenders case, not just the trust, not just the trustee, but what about additional advocates? What about trust protectors? What about trust distribution committees or care committees? In certain states, individuals who have the ability to retain decision-making authority, they don't need a conservator or a guardian. They can also designate somebody who has access to records on their behalf. It's not substituted judgment, it's assistance with communication and with preparing, financial type requests like this, right? So the world is evolving, and we don't necessarily need a restrictive solution for individuals that have discretionary trust, but we need to facilitate a conversation around a supportive network for these individuals. And your client may not know that. They may not have uncovered all of the options that are available for their beneficiary. So that's an extension, not just your client. Just off and visualize the plans. Lots of you are having these conversations. Hard to get those old estate plans out of the drawer, see if they need any work, have circumstances changed. We still see the old AB trusts, right? Marital trust only funded to the extent the estate exceeds the federal exemption. A lot of our clients don't exceed the federal exemption now. If we don't have anything major happen with Congress, maybe they won't for a while yet. So it's important, just because the client doesn't have a federally taxable estate now doesn't mean that there isn't a missed opportunity with pulling out those old structures. Perhaps in this case, to be able to retain the ability to have a step up in basis. So under these plans, if the B trust is going to get funded, as we all know, that's the family trust or the credit shelter trust. You miss an opportunity to get a step up in basis upon the death of the surviving spouse, right? That may be an opportunity that your clients want to take advantage of. They want to change the structure. For other reasons, an AB type structure still makes sense. For example, blended families. But if they're not getting them out of the drawer and thinking about, what they're willing to trade off and, what kinds of conversations they want to have, then we have a missed opportunity. So this is another monitoring example. So the big lesson learned here is, it's not just about the taxes. There's unintended consequences from those old structures, but sometimes it's about the taxes. So this is the final. We're wrapping it up. So taxes again. A lot of focus on federal estate tax for a while. Still focus on state estate and inheritance tax. What about state trust income tax regimes? This case we thought would just rock the world from an estate planning and financial planning perspective. Is about 2019. Here in New York, the client, Joe, created his trust in New York. He lived in New York. He named a New York trustee. The trust, for all intensive purposes, lived in New York. But one of his daughters, who was a beneficiary, she moved to North Carolina. And North Carolina assessed $1.3 million worth of state income tax on that trust over a period of 5 years, even though the only nexus to North Carolina was the fact the beneficiary had moved there. She never even got distributions. This is another one that had to go all the way up to court. So, what is the solution here or the lesson learned? What I'm going to say to you all is like, this is one we have to tackle collectively as a community. The lawyers, the CPAs, the advisors, we have to raise it. What flexibility do we maintain within estate plans for these changes? Because it's oftentimes so much about the contacts that the trust and the beneficiaries or trustees have with these states, right? So not only how can we plan now, but how can we keep that flexibility? And it really is a quagmire. Different laws in each states. Did somebody die here? Does somebody have an office here? Incredibly complicated. The lesson learned is we have to start talking about it as a community. So then that way we can present options to our clients and facilitate really a full court press by all professionals. So in summary, what are you going to do? Prompt the thoughtful consideration of fiduciaries and discuss the flexibility when those fiduciaries don't work out. Reduce the risk of delay to the extent possible. Second, guess simplicity. Simplicity is not always the best course. Help the client think about that. Figure out how changes are going to be monitored on the estate plan. Raise accounting considerations. Income for accounting purposes, not necessarily the same thing as taxable income. Ensure the distribution standards were actually given earnest consideration, that they're not boilerplate, that your client thought about it, has an idea of what it means and what it doesn't mean and why it's there. Highlight discretionary trusts, maybe help them create a supportive environment for those beneficiaries. Model the asset waterfall, the plan, the assets, what it looks like today, who gets what, how does that AB trust actually work right now? We got to create this state income tax awareness. Okay. So if you want to join the community, please join the estate planning waitlist. Really fantastic opportunity to share with one another, to learn what other folks in our industry are struggling with, how they're addressing estate planning needs currently, and inform the future of our product. We are building this product for you, for your clients, and I'm really excited. So I think we have only a few minutes. I'm sorry. I tried to keep it as short as possible for some questions.
All right, Erin, thank you so much. That was
Absolutely.
one of the things that I think is most astounding about your presentation is these are all real life experiences that you have lived and seen lived out, which is pretty crazy. I mean, that North Carolina one with that like $1.5 million income to, oh, that's brutal.
It adds up, Laura. I'm really quite tired now.
That's fair. It seems fair. All right, so we have a couple of questions. We have about 3 minutes, so probably 1 to 2 questions. So Alex asked, ABC Trust, still useful?
Yes. Obviously. And again, like useful for different reasons. So that's the thing about estate planning that, keeps all of us folks in business for a long time, but it's also what makes it complex and difficult to scale. So we need software and we need community, right? We don't know. We don't have the crystal ball of the exemption amount. Some folks need to use an ABC trust structure specifically for state estate tax purposes. Some folks want to at least keep an AB type structure because of, for example, a blended family. So we don't throw the baby out with the bathwater. We uncover the goals, we look at the current facts, and we raise the opportunities and get them to the experts that they need. Sometimes we're the expert, as the advisor. Sometimes we're just part of the community of experts.
Okay, that's fair. We have a lot of very specific questions. Here's one that might apply to more people. So this one comes from John. He says, "Is there a good solution to the digital record keeping problem?"
Yeah, another thing that we all have to do, right? Some would say joint, not an individual trustee where the individual can become incapacitated or deceased. There's also obviously digital record keeping provisions. You can share passcodes and things like that. I don't think any individual trustee would necessarily feel comfortable with doing that though, right? Because giving access to those passwords, you really are opening up those accounts, not to a beneficiary. But yeah, it is a quagmire. Mostly I see joint trustees.
Okay. Okay, and then the last question is, when will the estate planning tool be available?
It's a good question. All right. So, from our perspective, we are building a tool that is going to allow you to decide you want to go broad, you need to go broad depending on your client circumstances. Maybe they're just starting out, or you need to go deep, right? So our goal right now is making sure that the product is a fit for our advisors. We do have folks in beta. They are giving us great examples of real life things that they would like to see that we think you all want to see too. So if you join that wait list, you are going to be getting updates and teasers as we move along to rollout.
Which, I mean, the product team is super, super hard at work, making tremendous progress week over week. So we're in a really exciting phase, I think.
Yep, me too.
All right. Well, I want to say thank you so much, Erin. It is amazing having you on here at the Tax Summit. It's been incredibly insightful to hear your stories about different estate planning gotchas. And if you guys want to drop into the comments just some love for Erin to let her know we really enjoyed her presentation, that would be fantastic. So
Thank you.
thank you very much, Erin.